counting the days until tomorrow, counting the nights till I'm with you. Slowly they hurry by, no need to
I'd like to call to order the meeting of the Santa Barbara City Ordinance Committee, City Council Ordinance Committee. Ms. Peterson, would you please call the roll?
Ordinance Committee Chair Bendy White.
Here.
Committee Member Grant House.
Here.
Committee Member Frank Hotchkiss.
Here.
Thank you. So today we are considering further the medical marijuana dispensary ordinance revisions, and Mr. Wiley, as I understand it, it'll work for us to continue the deliberations, and then if we have time at the end, we'll ask for public testimony on the changes to the ordinance. Is that a reasonable way to take it? Great. Thank you. So that'll be how we'll go today, and we'll be expecting to be done about 10 minutes to 2 at the latest. So with that, do we have staff input at this point, Mr. Cato?
Yes, please. I just have a quick PowerPoint to show you. Just a bit of recent history. Council gave direction to the Ordinance Committee on the 23rd. Ordinance Committee has held discussions on March 16th and March 16th, March 30th. On the 30th, it seemed like there was consensus on some points and not consensus on some points. I just wanted to point those out. Storefront, consensus items. Storefronts only allowed for not-for-profit collectors or cooperatives. Cultivation within the Tri-County area with documentation. Collective membership and financial documentation available to specified city staff, and site visits with limited notice to specified city staff. Oh, did I miss something? Yes. Protection for the YMCA. And actually, you know what? The way, I can show you that if you want, the way we looked at that mapping and the direction that we got from Ordinance Committee, it actually doesn't change the block faces and the allowed areas. So I'll show you that if you like. A prohibition on existing mixed-use buildings with residential condos, not allowed on blocks zoned exclusively for residential use, and a maximum of 5 collectives. And I'm not actually sure that there was consensus on the 5. So it was written that way in the staff report, and and that's the way that it's written in the draft ordinance, but that's, I'm not sure about that one. Okay, areas with no consensus. Which recovery facilities to protect? Is it the full 17? And actually, if you remember, only 6 of those had an effect on the allowed areas, or fewer. The elimination of the downtown as an allowable area. The hours of operation. Should there be hours of operation, first of all, and then the school district had a idea of closing during lunch and, you know, the hour after school close. And then a county residency requirement for collective members. I'm not sure if we got to consensus on that one either. So the draft ordinance that is attached as it's attached to the staff report that has the consensus items in it and the not consensus items not in it. And our recommendation is to review the draft ordinance, discuss the items that don't have consensus, and if there is no consensus or unanimous decision, you know, if you could give me some guidance on how to present that when we go back to council. Do we want to have the minority position outlined or not? And then make recommendations to council. I know that Mr. Wiley has some overheads that he'd like to go over as well. I have a whole bunch of backup slides if you want to look at anything from previous presentations, but that's pretty much what I have.
Great. Thank you, Mr. Cato. Does anybody of the committee want to see any of Mr. Cato's backup at this point? All right. Then, Mr. Wiley, would you please review the draft portions of the ordinance that you've worked on?
Thank you, Mr. Chair. You know, I might add at the beginning, in preparing this draft ordinance, I think in preparing the staff report for today's hearing, I know I reviewed the online video of the committee's meeting last week and prior meetings, and in an effort to really understand if a consensus was being expressed on any particular point. And I have to say that there are some where it's just not clear, and we took our best guess. I bring it up mostly because we're getting down to the crux of the matter, I feel, and we really should try to focus on whether there is, at least 2 out of 3 committee members supporting a particular point, and if that's true, then maybe directing staff to at least incorporate that into an ordinance. And of course, ultimately, this all needs to be approved by the City Council. In fact, approved by 5 members of the City Council, since it's a Title 28 ordinance at this point. The draft ordinance that was included in your package for today's meeting shows the changes both from the existing March 2008 ordinance, that's in just single underline and in single strikeout, the strikeout being deletions, and in double underline and double strikeout. And the double underline are new provisions recently added by me, I believe, at the consensus direction of the committee. I would have to say that the bulk of those occur beginning at page 6 in the ordinance, the draft ordinance, where we really identify this more now as a collective dispensary. The concept that, well, let me back up. As we've discussed several times, the Compassionate Use Act, Prop 215, and the state statutes are pretty clear that they allow a small group of individuals to cultivate and to share marijuana among themselves. Those individuals should be qualified patients and primary caregivers. And if they just do that on their own, privately, without a storefront, in other words, they really don't involve the city. And if they do it in accordance with the state laws, there shouldn't be any city issues, particularly zoning issues. And so that's kind of our baseline. That's occurring. We really can't even regulate that in a way when it's occurring what I would call at that private level. Maybe the marijuana is exchanged in someone's home at a little get-together or something like that. So when the city becomes involved, really when these collectives are distributing it through a storefront. At least that's been the fundamental basis, that's been our presumption as to why we've got a zoning concern and why the city needs to regulate this. And I think that would be true, that is true of most cities now that are regulating this. And in fact, most cities, or many cities have imposed moratoriums on collective dispensaries while they figure this out. So the main change in this draft ordinance is moving to really clearly identify the collective model as the appropriate model, and in a sense creating this term called the collective storefront dispensary, where a collective, instead of maybe distributing the marijuana that they've cultivated in a private home privately, are distributing it at a storefront location. And when they do that, beginning at page 11, we start to impose some requirements on them, with these requirements aimed at the city's ability to verify that they're operating as a collective in accordance with state law. And for example, at page 11, we actually had some security and some camera video requirements in the existing ordinance, but this language is much more explicit about monitoring the property via closed circuit television at all times. And then at page 13, we start to impose, at least this draft starts to impose some more specific requirements. For example, the bottom of 13, subparagraph I, mandates that the collective dispensary, have a conspicuous sign posted in a conspicuous location that really advises people that, if you will, the non-compassionate use act of marijuana or possession or distribution of marijuana outside of the Compassionate Use Act remains illegal. Then we get into that it be a not-for-profit operation. And we've discussed this, that when medical marijuana is distributed under the Compassionate Use Act, there can be some money that changes hands. The state law is clear that the person who cultivates, processes, and distributes the marijuana can be reimbursed for their expenses. And so money can change hands, but the real question is whether the person who is distributing the marijuana can make a profit on the distribution. And at least in my review of the state law, I think it's pretty clear that they can't. But it's not a simple equation, because the state laws do anticipate some compensation for someone's time that's involved, the assistance in helping, for example, a primary caregiver cultivate marijuana can be compensated. So that's a pretty fine line. It's drawn by, again, it's drawn by the state statutes, and we can't change that. So, and just as an aside, I think a lot of people look at an ordinance like this or other cities, and they say, well, you're doing something here that isn't, we don't think is appropriate, or you're doing something that is allowing something outside your jurisdiction. It's like, no, we're really not. We probably say it 3 or 4 times in this ordinance. We're not allowing anything that isn't already allowed by state law, and we're not prohibiting anything that isn't already prohibited by state law. The whole concept here is to supplement state law in a manner that's consistent with state law, such that we address our local concerns, our city of Santa Barbara, our zoning concerns. So that's an aside. But getting back to this draft of the ordinance, which really tries to get at being able for the city to say, this storefront dispensary is being operated in a collective mode, in imposing those requirements. And I should mention, rather than keep saying collective, cooperative, and I've adopted the approach of just saying collective. It's the broader term. It's actually, because it's an undefined legal term, not defined legally, it's a broader term than the term cooperative. But in saying collective, I mean cooperative or collective, as the state law does. So we impose a requirement that the cultivation of marijuana is limited to the collective members. And we actually have this concept of the management members, because in trying to verify that this is all a collective operation, it seems would be important to identify who's running the show, who are the management people, to know who they are precisely, how they can be contacted by the city, and basically how the people who would interact with the city officials that would be enforcing this ordinance. So there is this concept of management members. There's also, and I think we've seen this in Santa Barbara and other cities, I know that maybe the police department could provide more details on this. There is a concern that when marijuana is being cultivated, that it's a temptation for burglars or for crime. And so we attempt to impose a requirement that if it is cultivated if it is cultivated by the collective, that it be cultivated in a way that's very secure, that's not obvious, that's not something where you could simply stick your head over a 5-foot fence and see marijuana being cultivated. I think the committee last week suggested that we would like to limit the cultivation to the tri-county areas, and that's been included in this ordinance. We also have a requirement, for example, that you can only be a member of one collective. That's not something that's mentioned in state law. It's not something that's imposed in state law. Yet I don't think having a city ordinance that says you can only be a member of one collective would be inconsistent with state law, because of the concept of how a primary caregiver is defined. And it is pretty specific, and it's not easy to become someone's primary caregiver, because it means you are offering responsibility for the health, housing, or safety needs of an individual, of a qualified patient. Then, in a sense, having imposed those requirements, and I mentioned this last time, to really be realistic, to have any possibility of effectively enforcing those requirements, we've got to have records, and we've got to have city access to the records, cultivation records, where, how much, who's doing it, and then records with respect to the membership of the collective, and records with respect to the finances. That's money that is changing hands, the expenses that are occurring that are supposed to match up. This ordinance would require that those records be maintained, and be maintained for a certain period of time, for 3 years, and allow city access to those records. Now, this ordinance, and this is something that occurred to me, and I believe it's feasible, would only allow city access if we had a search warrant or an inspection warrant, because there is a legitimate concern that to say city access to the records might be too broad. Even to say financial staff might have access, or police department might have access. These are, in a sense, medical records, at least, for example, the membership records of who's a qualified patient. And there is a legitimate confidentiality concern. On the other hand, the city presumably would not need to necessarily be proactive about demanding seeing these records. In other words, we could, as you do typically with any sort of enforcement of a criminal law, wait until we have evidence of a violation. And at the point that the city has evidence of a violation, probable cause, in other words, we could obtain a search warrant, and the inspection people, whether that's zoning inspectors or fire inspectors and city attorney's office, we do this on a regular basis. There's something called an inspection warrant. It is also issued by a judge, just like a search warrant. And it does require a form of probable cause. It's not the criminal probable cause. It's essentially reasonable suspicion that a local ordinance has been violated, that a judge could issue a warrant and we could go in and look at the records. I think that might be an appropriate protection to include in this ordinance. Again, if it allows the police to react if they do have probable cause that a violation is occurring. That's pretty much the extent of the changes to this ordinance beyond what the amendments that were proposed last fall to the March 2008 ordinance. There is somewhat of an issue that I see other cities trying to deal with, and perhaps we want to deal with, and that's the question of edibles, or edible medical marijuana products. And I've heard or read of problems, health regulation problems with that, because of the nature of how edible products are prepared. They're not regulated by health departments, and that it might be a possible health concern. I think some cities in their ordinances for that reason have just banned the collective storefront dispensary distribution of edibles. Again, if state law allows us to do this to be done, and apparently it does, on a private basis, on a smaller scale basis, if you will, among qualified caregivers and qualified patients and primary caregivers, we're not prohibiting that. We're just prohibiting it at storefront collectives, if that's where the right way we go. That's the extent of my summary of this draft ordinance. I do also have the bullet points. It's sort of...
Mr. Wiley, is that edible exclusion in here?
Yes, it is.
Where is that?
That's at page 16,
Okay. Thank
right
you.
there at 090.
Thank you. Got it. Thank you.
I did, as I say, I prepared 12 bullet points that sort of, again, get back to these things, and if the committee'd like, I can go over those. It sort of repeats what I just summarized, but it sometimes helps to have bullet points up just to focus and to move on and maybe even reach a consensus.
Thank you, Mr. Wiley. Would the committee like to have him review the 12 bullet points before we begin our deliberation?
The 12 bullet points being, I'm sorry?
Well, Mr. Wiley has he's given the narrative of the changes and the shape of the draft ordinance. He's got his 12 bullet points up there.
Mr. Chair, I'm ready to literally walk through what we have in front of us, and I have, for me, I've highlighted some things I was hoping we would discuss and maybe just settle on. Some of them may not be so controversial, but I'm ready to do that.
Okay, great. Mr. Hotchkiss? Okay. Very good. Thank you, Mr. Wiley. Does staff have anything else at this point? Okay. Well, then, Mr. House. First of all, I want to ask Ms. Peterson how many... Mr. Martel?
Martel.
Yes,
I want to say Miguel Martel, but anyway. Armando.
Chair and committee members, just a brief comment in regards to what Mr. Wiley had mentioned in regards to the warrant, the request of a warrant. I would maybe think or just propose maybe a little broader to make it a little more clear for the businesses or the neighboring businesses or the community to allow us access to the business without getting a warrant, where we get simple complaints that of the business and being able to go in there without actually going to court to get a warrant. Going to court to get a warrant, even a simple warrant, does require resources, where I can simply, if I get a complaint, I can go to the business and deal with it there without getting shut at the door. So you need a warrant before you come in and review our records. So
Okay.
I would just...
You want to put that issue on the table, and perhaps Mr. Wiley and you can dialogue this one. And
Mr. Chair, I should have mentioned, and there is a major exception to the warrant requirement that the police department uses on a regular basis at an officer level, and that's called the consent exception. And that's where an officer says, do you mind if I look in your trunk? And says, no, go ahead. That's consent. So we're not changing that. I think that's one point. And secondly, I'm only suggesting the warrant requirement with respect to records, and just be clear about that. Nothing would prevent the police department or any city person to go in the public area of a dispensary and ask questions or inquire or contact them and say, we've had a complaint that it's been too noisy or whatever. That it's just access to the records themselves.
Mr. Martel.
Chair and committee, I would just say, just in the issue of transparency, I would like to see a little bit broader view. I'm not sure if HIPAA, if there's any requirements really solidifying that there's requirements to for confidentiality in the area of medical marijuana dispensaries. I'm not sure about that. That's something more Mr. Wiley can handle. But I just want to make sure it's clear that we have equal access to all throughout the business, and that would include the records without getting a warrant. And I also think that should be applicable to if we're looking at this thing in regards to the annual inspection, that I don't have to apply to get a warrant for that.
Okay, so the two main points are the sort of spontaneous or short-term inspection is one concern, and the other one is the annual inspection And the police department's view would be that having access to the records be to the maximum extent feasible, that occur. And then Mr. Wiley has said those are medical records that have an issue of confidentiality around them. So we have a tension here between, at least I'm hearing that there's a gap between what the police department would like and what our council is saying is feasible. Is that what, am I reading that right?
I think that's correct, and let me just put it this way. I would, as a lawyer, recommend we have a warrant requirement particularly for the membership records.
Okay.
I just, thinking it through and looking at what some other cities have done on this, I think it would be the safest legal course, and I think it also would be quite appropriate that before we demand to see records, particularly membership records, that we have probable cause to understand that there's some violation, and that's the only thing that's necessary in order to get a warrant.
Okay. Thank you. I'm going to back up 1 second, and that is, everybody who wants to speak, I ask that you provide Ms. Peterson with a slip. And so if there's some that haven't provided slips already, please provide them. And then, Ms. Peterson, where are we on terms of numbers of slips at this point? We have 12. Okay, great. So I'm just going to try and budget that in. Mr. House.
Well, then, since we are opening up to public comment, perhaps we should hear from the public before we start walking our way through, because maybe some of the things we hear from them would help us with our discussion today.
Okay.
So I'd rather defer to the public's comment before we start doing this.
Okay. And Mr. Hotchkiss?
Sure, we can do that. I think most of the speakers, honestly, we've heard from before, and it's not a politic thing to say, but I would like to move this along because I do think there's some important issues, and we're tugging on at opposite ends of the rope here. But I would like, maybe by the time we get out of here, to have something. But if your preference is to hear public comment, let's do it, gentlemen. I defer.
Okay. Well, we have 12 speakers now. Is that total now? 14 now. So that means 28. With about a half an hour. That will take us to 1 o'clock. To have a rapid fire, to the point public testimony on the changes to the ordinance.
Right. We're requesting, I think, then that what folks are addressing are what we have here in our staff report today, the changes that are being put forward for us to discuss.
Right. So I will then open the public testimony. Marge Schwartz to be followed by Derek Weston. Hello, Ms. Schwartz. No.
Okay.
Now it is.
Okay. I'm not only an advocate for people with disabilities, but I'm also an advocate for children's safety and for people with substance abuse problems. That's why I support unlimited access to medical cannabis. The City of Santa Barbara should treat all pharmaceuticals, outlets, and nonprofits, including Cottage Hospital, equally as they do dispensaries with the same exact regulations. Otherwise, these Jim Crow regulations will force people to take cannabis in its synthetic pharmaceutical form. It's very expensive, it's ineffective, this is unfair, and may be illegal. Now I'm going to say why I support medical cannabis. The United States' own drug czar has declared marijuana is not a gateway drug. The actual gateway drugs were proven to be alcohol and nicotine. Studies done with pregnant women who regularly smoke marijuana found no evidence of developmental impairment, and actually improvements were observed. That was done in Jamaica. And other studies done in Costa Rica, for example, has found that marijuana smokers live longer, healthier lives than non-smokers. Cannabis has been successfully used to help end addiction. Unlike barely tested pharmaceuticals, all of which are toxic, cannabis has been used effectively for centuries with no negative effects. In fact, the United States was used in most medicines, including children's medicines, without any harm. The pharmaceutical industry, which has synthesized many of the cannabis medicinal properties, such as in Marinol and dopamine, a very expensive pill form, still cannot compete with the results of using cannabis in its natural state, so they resort to spending big bucks to promote their monopoly through lies. That's why I think all these regulations are based on untruths. like the WMDs got us into these wars.
20 seconds.
It's all based on lies. All people, including children, should have access to the safe natural remedy in its affordable natural state. As the DEA's own conservative law judge, Francis Young, said in 1988, marijuana is one of the safest
5
substances known to man. Let decisions concerning cannabis be based on facts and science, not prejudiced, unfounded fears based on...
Okay, you need to wrap up.
Okay. Ignorance
you.
and propaganda.
Thank you.
Okay.
Mr. Weston?
Thank you very much. I'm here on behalf of the Santa Barbara Collective.
Excuse me 1 second. Followed by Denise Felbas. Thank you.
And Heather Poe-Johnson has filed a slip, but we'll cede her time. In response to Mr. Hotchkiss's comment, I am only going to talk about the issues that are new in the draft ordinance today, and I appreciate it that you've taken testimony on it. I think you should not adopt new ideas without opportunity for comment. So I'll try and be quick.
Thank you.
On page 7.060 subsection E, I have a concern about that language, and we'll take this up with Mr. Wiley, whether it would permit the Santa Barbara Collective to obtain a new permit for a new location and close the old location without violating the number restriction. So it's just a technical problem. I don't think that's intended, and I want to make sure the wording allows it. Second point, on page 8 under 070 sections C, 4, and 5, you only allow visits to a collective by qualified members, and that would prohibit you visiting, and I know a number of you have it, prohibit me visiting on legal business, and I think that language should be, you should re-include the language about people with a legitimate purpose and maybe other wording, but it can't just be collective members. So on the principal points, I do have a concern with limiting suppliers only to the tri-counties. And let me give you 2 specific concerns about that. Santa Barbara Collective has one supplier in Los Angeles who only supplies to the Santa Barbara Collective, has done so for many years. They consider that entity to be one of the most caring and responsible and safe providers. And they'd prefer not to have to stop using that as a supplier. That person is a member of the collective. So we don't, on reflection, we don't see a reason for that restriction, as long as they're only supplying to one person. And there's a related issue with the supplying of edibles. There are some patients for whom inhalation of medical marijuana would really be unsafe and would never be recommended by a doctor. The ideal solution is to have really qualified providers like bakeries under carefully controlled conditions who can receive marijuana from the collective, process it into edibles, and then return it. Now, to be honest, I think you can't just make an exception. An exception. I think you would need another whole, section of the ordinance that deals with it to make sure that it's safe and controlled and quantities are controlled.
Okay,
and we
I'll let you go beyond your time. Have you got your client's time?
Yes.
Okay, so let's do
But I'm near the end. So I think I wanted to flag the issue because I think the ideal solution is to have edibles made by really qualified people, like a good bakery. Otherwise, members of the collective are doing it, and it is not as safe. But I think you may need another whole section of the ordinance to make sure the city's protected, and those are our primary concerns.
Well, thank you for your focused testimony. And that is Jen Lemberger. That's you? That's right?
No.
Oh, that's you. Excuse me. And then I actually had called Denise Felbas. Is that you?
Fellows. Denise Fellows.
Excuse me.
Thank you.
Followed by
Sorry.
Jen Lemberger.
Okay, great. Thank you. I do also want to address the consumption restrictions in point E and edibles. I really believe that it's been shown throughout the state that this has been the area that's been very accessible to children. It's been reported recently that in other areas throughout the tri-counties, children have ended up with medical marijuana suckers. As a consumer, I would never want to purchase something from a bakery, quite frankly. No offense to Mr. Weston, but I wouldn't want to purchase anything from a bakery that used medical marijuana. I would be afraid of cross-contamination. So I don't see that as an area. I think it's an area that should be severely limited, if not completely eliminated, the edible portion of medical marijuana for local consumers. I also am very concerned for the school children in our area. They're walking by these Milpas dispensaries at the lunch hour and after school. I would really ask the City Council reconsider and restrict the hours of operations. We have too many high schoolers out there after school and at lunchtime purchasing medical marijuana. I also want to make the additional point that I don't believe that the police force should be limited to inspection because of HIPAA regulations. This is an illegal drug, so I don't believe it falls under the HIPAA regulations that affects other medications. So I would ask you to look at that more closely, Mr. Wiley. And also from the perspective that really our medical community, if you look at the medical society news, they are not embracing medical marijuana, and they are really asking about the frankly, the good standing of the physicians that are prescribing medical marijuana. And I would ask that we check that these people are appropriately licensed to practice medicine in our community, and that they are following up with their patients. Thank you.
Thank you very much. That is Jen Lindberger, followed by Shireen Karapush.
I'm Jen Lemberger. You've all seen me before. And again, I just want to point out that you see those of us in red to support our Drug for Youth and to outwardly show our concern on this specific topic. And I would like to address, again, helping to aid our vulnerable and impressionable populations, such as our youth and those in recovery. And this includes not just the location issues, but again, the edibles and the types of items that are available within the cooperatives, collectives, specifically items that are much more amenable to the youth, the brownies, the lollipops, those forms of edible items. And as well, we really want to make sure that there's truly a limit to the number of the dispensaries, cooperatives, collectives, to a necessary level for the actual need in our community. The way it's currently written, there's not a clear, it says there's the 8 zones, and are we going with the 5, are we going with the 3? And so we just want to make sure that that is specifically and clearly defined for the need in our community.
Thank you very much. Ms. Karapush, followed by Sharon Byrne.
I like the way you say my last name, Poosh. I don't really have specific comments on this current draft. You know that I work for the Council on Alcoholism and Drug Abuse, and I just feel like it's important for you to hear from me again that we support a ban. Our mission is to protect the safety and health of the community, and while in theory we support limitations, any limitations that you would put into effect, we really support a ban. Thank you.
Thank you. Sharon Byrne, to be followed by Tony Vasallo.
Hi, I just want to say a couple of things. One is we'd like to extend our support to several of the ideas Mr. Hotchkiss proposed in the last Ordinance Committee meeting. They were carefully put together to protect youth, and we support that. Mr. White, you suggested you'd like to see a cap of 2 to 3. If we couldn't have a ban, 2 to 3 would be fine. We actually strongly support that as well. Some of the things that are not in the ordinance yet that I would like to see get in there is more movement towards what a true collective is. There was a documentary film that several of us saw this weekend on medical marijuana in California. There's an organization up north called Women's Alliance for Medical Marijuana. They're a true collective. They don't sell the pot. They take care of their patients, and everyone participates in the cultivation. And to date, they have compassionately assisted and been there for 132 of their members' deaths. Very supportive, very compassionate. That was the actual intent of the state law. So far, nothing we have in the city looks anything like that. We have $99 specials, buy one, get one free, drive up from Oxnard, pick it up. That's not what the state law intended. So I'd like to see more limiting language in there around cultivation. I haven't seen that yet. It probably should be limited to 25 square feet within the city limits. We don't have jurisdiction in the county. We also could stand to have things such as, you mentioned this in the last committee meeting, mutually beneficial corporations. Those are an IRS code for a nonprofit corporation, and it ensures that there's no profit in the business, that everything is done for everyone in the organization's benefit. So we'd like to support those kinds of recommendations. Thank you.
Thank you, Ms. Byrne. Tony Vasallo, followed by Janet Rouse.
Yes, Mr. Chairman, I'd like to focus all my comments around the location of dispensaries and collectives. The recent documentary that Sharon mentioned, Cash Crop, was a real eye-opener. It featured Santa Barbara as one of the friendliest pot cities between Los Angeles and Mendocino. We really need to be doing everything possible to get our community off the stoners friendly to marijuana city list. And we can start by not allowing dispensaries near any drug or alcohol recovery facility downtown or near downtown's many housing authority projects. The proximity just increases the risk of drug abuse by those residents, and it sabotages their chance for recovery. Another way to get off the pot-friendly map is to keep dispensaries far away from downtown. They really don't belong anywhere near our downtown area because of our city image that we're trying to foster for our tourist industry so it can thrive. On one technical point regarding location, I would highly suggest and hope that you would look carefully at requiring a conditional use permit process for dispensary reviews instead of the performance standard checklist. The CUP is has more teeth to it. Lastly, no marijuana storefronts really belong in the predominantly Latino East Side and West Side downtown neighborhoods. They need help in their struggle to remain safe and stable. And they're constantly enduring the experience of serious and often violent crimes from gang activity.
20 seconds.
And this fact was driven home by the county prosecutor who publicly said crimes increase around storefront dispensaries. So we really don't need them in those neighborhoods. Thank you, sir.
Thank you, Mr. Vassallo. Janet Rouse, followed by David Hughes.
Hi again. Thank you for your attention to this. And I know you're getting tired of this, and so are we. We haven't changed our point of view. We still believe that we would like to see 1,000 feet buffers for the recovery facilities and sensitive use areas, including schools. And that still is not a part of what you're interested in following, but we want you to know that we still would like to see that. And we're also concerned about the enforcement issue. We've heard that having these storefronts will make these things controllable, and that non-conforming facilities can only be shut down once we've adopted this ordinance. Well, the illegal ones have not been shut down, and I know you had some discussion earlier on about that, but they're getting raided and then they're reopening. So the citizens don't really believe you, quite frankly. We don't believe that you have any control over them at all. We would also ask that you really and seriously, truly follow state law. Take the advice of the city attorney. You know, he's sitting there for a reason, so we really would ask that you listen to him and put those things into your ordinance. And the one last thing I'd like to say is that when it comes to what you've presented for us, it seems that we came back here to the revisions to look at definitions. And it seems that those still really haven't been clarified in a really great way. So defining what exactly your dispensary collective is, what it can do, what it can't do, all of that in a really, really clear way that eliminates people coming in and going out and also the resale. Thank you very much.
Thank you, Ms. Rouse. David Hughes.
Good afternoon, David Hughes.
To be followed by Bonnie Raisin. Excuse me.
I sent you a short letter yesterday addressing some specific points. The revisions made since the last meeting, a lot of great changes, improvements to the previous ordinance. Let me go into two specific points. Page 9, Section F of 288007, which allows resale sales of other items by dispensaries, commercial sales of items, products, uses, and services. One, would urge you to delete that in its entirety. There's nothing in the Medical Marijuana Program Act, there's nothing in the Attorney General's guidelines which would in any way suggest that a collective can be engaged in the commercial retail sales of anything, whether it be marijuana or anything else. So I would urge you to delete Section F on page 9 and 10. On page 14, subsection 3 of 2880.070I, I will take a position in direct opposition to that of my esteemed colleague, who I very much respect, and that's Mr. Weston. You should not allow the cultivation of medical marijuana outside the city limits of the city of Santa Barbara. There's no express need for it. There's been no proven need for it. You don't have the authority to regulate cultivation in some other county, some other jurisdiction. How do your police forces go and enforce your regulations in another county, another city? There is nothing in the law which suggests in any way or implies in any way that there should be providers or suppliers of marijuana. It shouldn't be supplied from Los Angeles, Del Norte County, Eureka, or anywhere. It should be cultivated locally.
20 seconds.
Because the Attorney General says you need a closed circuit, cultivation and use by the members, and that occurs here in the city. Thank you.
Great. Thank you, Mr. Hughes. Bonnie Raisin, followed by Jeffrey Wood.
Good afternoon, members of the Ordinance Committee. I'm Bonnie Raisin. I really did not want to come here today to say the same things over and over again. And I have heard from the other speakers today pretty much everything they say I agree with. So I'm not going to belabor any of the points except to say that I have from the beginning been opposed to more than one medical marijuana dispensary. I definitely believe wholeheartedly that a study in Jamaica about marijuana being a gateway drug is not a valid research project to bring forth at this time. I think we need to base any research that excludes medical marijuana as being a gateway drug that isn't relevant to our immediate discussion and area primarily, as Kada has so well pointed out. I also would like to say that the one medical marijuana dispensary, which I am not under the illusion that we're going to get just one, 1,000-foot parameter is important to me on that. And I would also like to say finally that law enforcement must absolutely be used to close every single medical marijuana dispensary that is not permitted to date. And I also hope that that the body of people who are here are so resolute about wanting a curtailment, an expansion, a better, closer, tighter definition of what the state law intended, and that is medicinal marijuana for people who are suffering. Thank you.
Thank you, Ms. Raisin. Jeffrey Wood, to be followed by Marie Mender.
Good afternoon. I'll keep it very brief. The only thing that I really oppose is the free access of any city involvement in taking records. I do believe that these recommendations are done between a doctor and a caregiver. Some of that information is extremely private, and when put into the wrong hands can be extremely damaging, not only to the caregiver but to the patient, and it can cause severe detriment to health, mentally and physically. All I have to say. Thank you.
Thank you. Marie Mender, followed by Heather Poet, who I'll speak about in a second.
Good afternoon. My name is Mary Mender. I'm a parent here in Santa Barbara of 2 beautiful daughters and 2 young adults. And I'm also a nurse for 18 years at Santa Barbara Cottage Hospital, alcohol and drug rehab, as well as psychiatry and mental health. And I would like to let you know that nowhere is it addressed that we have talked about before the 1,000-foot buffer zone between any school, any youth center, any public park, or any drug and alcohol rehab center. It's very important that you realize that vulnerable people that live in Santa Barbara need our protection. Those that are unwilling or unable to control their own behavior need our support. And I want you to know that I have personally spoken to hundreds and hundreds of people in Santa Barbara. I've gone around and I've collected many, many signatures on people that agree with me. All kinds of people, business owners, healthcare workers, moms and dads, kids are even signing petitions because they want to be safe going to school. Now, medical marijuana, in my mind, the Compassionate Use Act, which I voted for, has a place in our world. Retail sales of medical marijuana does not have a place in our world. It was never meant to be the unfettered retail sales of a dangerous drug. Many drugs are dangerous, those that are prescribed and those that are abused. This is a dangerous drug when it's abused. I've seen it for 18 years. Thank you.
Thank you. All right, Heather Poet is ceding her time to Derek Weston, and there was some 30 seconds left on that time, and Mr. Weston wants to take it for a point that he forgot.
I did forget one very important
Followed
point.
by Mr. Donahue, John Donahue.
We don't object to keeping very detailed patient records, but are very, very concerned about patient confidentiality. We do not collect phone numbers for all patients of the collective, and we're not sure that's even allowed. So we just want to make sure that patient privacy is fully protected. And with respect to the sale of other items, we sell publications, books, and other written materials. So not paraphernalia, but I think that's a meaningful distinction.
Thank you. Mr. Donahue?
Council members, sorry I was late. I'm reading the new rules that you're imposing. It all seems pretty legitimate and sounds like a good idea to me. As far as the record keeping, though, like the gentleman before me said, it is still very private. People don't want that information out.
Okay.
Thank you.
Thank you very much. Okay. Well, that will then close the public testimony portion, and it'll be back to the committee. Mr. Haas, would you like to lead off?
Yes, sure. I definitely do. And I want to thank our staff for listening so well and getting so much of what we were talking about last time in here. And I just wanted to walk right through it. In the very beginning, on section 2880.010, that's on page 1, I had just something I think that maybe after all is said and done we might want to add, and that would be, and Mr. Weiler, some sort of an affirmative statement that that we are doing with this what was referenced in the state, which is that we are. So you use the actual language. Let me find it right here real quick. That the city is doing what we need to do for our city's interest. Here we go. It says in 11362.83, it says, nothing in this article shall prevent a city or other local governing body from adopting and enforcing laws consistent with this article. And I think that was really the intent of your remarks earlier, that we should be affirmatively stating that our intention is to be consistent with the state law and just have that be sort of an overarching principle. So I put that forward. Maybe the actual language should come back to us when it's refined, but we don't want any misunderstanding about that. Small point, maybe it's just a typo. Would you, Mr. Wiley, on page 2D, it says the title for that, it's kind of garbled for me. I don't quite understand what was meant there. Or maybe it's just a typographical error of some sort. It says medical marijuana collective dispensary and then it says collective/collective. You probably meant something else, I think. Okay, we'll leave that alone then. And I'm going to do some picayune type things. If you look down at the bottom of page 2, about 5 or 6 lines up from the bottom, it says Santa Barbara to collectively or cooperatively cultivate marijuana for medical purposes or to...
I'm not there yet. Wait a minute. Hang on.
There you
go. Mm-hmm. Or to distribute medical, and then there's an empty space. I think you meant medical marijuana there on that 6 lines up from the bottom, I think. Okay, and then you reference in that same sentence California Health and Safety Code sections 11362.5 at SEC. And do you also mean by that .7? I think you do. Do we need to say that out loud? Or because if you say .5, that would exclude the next piece.
Well, et sec is Latin for
follows.
And follows.
And what follows?
Yeah.
Okay, good. I'm just not an attorney, so. Skipping ahead, let's see. There was something that Mr. Wiley had mentioned last time that is sort of one of those overarching kind of things that comes up on page 4 for the first time under the 2880.030. And it talks about the Planning Commission's role and the staff hearing officer's role. And I was hoping that we'd just take a minute and maybe right here just certify. You had suggested, Mr. Wiley, that we had that one way of approaching this would be the way we have been doing, which is sort of from a land use perspective, zoning land use, in which case the staff hearing officer, the planning commission, et cetera, would have a role in making a decision. The other option which you proposed was more of a business model where if they comply with these things that we have here, then the financial officer or whomever makes those decisions about business licenses or whatever, that would make sure that there was compliance. If there wasn't, they just couldn't get their permit. Could you talk to us a little bit about that? Because this language continues to be in here about the Planning Commission and staff hearing officers' roles throughout the rest of the document.
Right. Councilmember House, there is, I think, maybe as one of our final questions on this, the question of whether, if the city has gotten much more strict about this, for example, limited the number of collective dispensaries from something to like 3 to 5, and has identified the block faces in a very specific and thoughtful way, and at the same time enhance the operational and security requirements and regulated this to a very extensive degree. The question then arises, what's left, what's really the role of planning staff and the Planning Commission in reviewing an application? Because it isn't, frankly, it isn't like a conditional use permit, which is very much a land use decision and a subjective land use decision. For example, in Santa Barbara, whether a school can be built, a new school can be built in a residential neighborhood, is a conditional use permit requirement. And frankly, it isn't the sort of thing that you can set real black and white rules for. Sometimes it's appropriate to have a school in a residence, works fine. Sometimes it not, and it all depends. That's a traditional, typical CUP requirement. This, I think, could move to the actual other end of the spectrum where it's gone out of becoming a planning issue and it's more of a regulatory issue, almost like, if you will, the way a pharmacy is regulated. Pharmacies don't go to planning commissions. And I'm not, in saying this, I'm not suggesting either model. The question does exist, and I think, though, the question might be best answered after we've dealt with the number of locations and the block faces and whether the radius will change and whether we're going to have single space or we're going to have a full page worth of regulations with respect to record keeping and access by city officials, non-planning officials, to those records. I think at that point we may want to ask ourselves, is there really an appropriate role for the Planning Commission and the planning staff?
Thank you. I think that may be the right way for us to approach it. I appreciate the commentary here, so we can really know when to really discuss that. Thank you. On page 5, there's a strikeout under A, 2880060A, and it was where, let's see, if we read this new sentence, it says medical marijuana collectives and dispensaries was crossed out, may only, etc. And if I go back to the real intent, which is identified at the very beginning, we're talking about medical marijuana dispensaries, and throughout the entire rest of the document we talk about these collective dispensaries, and we've adopted that language. We've even given it a definition, and this is the only place I could find where we pulled that away, which kind of puts us into that territory you talked about, Mr. Wiley, of the small little private kind of collectives, and I don't know that we want to go there. I'm suggesting we put the word dispensaries back in here so that we don't get a confusion about that.
Mr. Chair, I have to apologize. I tried to do a computer find and replace, and I don't know what happened. It just kind of, but let me just tell you, this ordinance, this draft, I tried to move to this concept of a collective dispensary. And when I did a find and replace for the word dispensary, it didn't quite work, and I didn't catch that until this had already gone out.
But
of the
it just,
packet.
I picked it up, and I want us to be consistent no matter what throughout the whole document.
So the idea here is to start using this term collective dispensary, and that is a collective that operates a storefront dispensary.
Mm-hmm. And it also, you've got it elsewhere somewhere, it also means the word cooperative, and we talked about that too, so we don't have to redo that. Okay, then on page 6, at the very top, we had a request from Cottage Hospital that we start using some different nomenclature with regards to that area, and I'm suggesting we talk about medical facility area, or perhaps there's some other way. We've been talking about that area of town, but they had made a request that we begin to not call it the Cottage Hospital area, but that we begin to call it something like the medical facility area or something. Mr. Cato, can we do that, do you think, or is there a better word for it?
Chair White, it was suggested that we use Oak Park. I mean,
Okay.
we'll think of something.
Well, I'm suggesting.
Okay.
I think I was thinking better. We're talking about this area that's zoned for medical facilities, and that has no name associated with it. So that was my recommendation.
Okay. Yeah.
We could maybe come up with something better, but anyway, okay. And then moving forward. If it's okay if I keep going, is this all right?
This is your.
All right, we're trying to.
You get your 15 minutes here. So.
Okay, do my best.
Only if you can do it in 10, that'll be fine.
Okay. On page 8, C3, which identifies the responsible for monitoring the real property of the collective dispensary activity, et cetera. And it says, for the purposes of controlling loitering. And I have I understand the intention of that and the rationale. Certainly having a guard outside does that. I was listening to our representative from the police department this morning talk about loitering when asked that we don't use that term anymore, and that it's very difficult to enforce against loitering. So how do we deal with that? Because I know that our wish is to make sure that the other regulations that we have in here are enforced, like no imbibing of the substance anywhere near the facility. So I'm going to just, without resolving it right now, I would ask Mr. Wiley to take a look at that and see if we can approach this issue of loitering in another way, because I know that we could get in, we just don't use that word anymore, and it's not illegal to stand around. So, the issue on number 4, just right below that, my concern was, what about maintenance workers, the owner of the building, suppliers? How do you deal with that, with the language that we have here that only allows? I know what the intention is, and I think it's on the right track. We just need to find some way to make sure that if the UPS guy comes, that comes to that front office, and there must be some way to distinguish that, or somebody needs to fix a hole in the roof. So that was mentioned by someone. The next one, it talks about, on 5, it says qualified patients. We've adopted the same language as the state, who distinguishes between card holders that have the state card and qualified patients. Throughout the rest of this, we've made that distinction. Here we just left it out. It should say qualified patients, and I think and card holders or something, because we have that distinguished. If you look at the way the state defines qualified patients, it's those who don't have a state card. And we might want to put that language back. Okay, just getting along real fast here, page 9. On E2, and now I'm going to, where it says collective dispensary operations shall not result in, etc. We actually find better language in here addressing that issue on page 16, and I want to refer to that because on 28.80.090, sale, distribution, and exchange of medical marijuana. Let me see if I find that. Right. We're talking, we need to find a better way to talk about this redistribution, because it is illegal to do that. The collective itself should not be in the business of doing that, and we're identifying that. But if one of the members would have done that, would go out and do something illegal like that, I don't see how the dispensary itself would then be See, it shall not result. It's so passive. I'm concerned about that language. And we talk about redistribution as being illegal. We call that to the attention in 2880090. And so I'm definitely worried about that. Illegal distribution, it is illegal to do that. And I've got some suggested language. Maybe I could go over that with you, Mr. Wiley, after today. But I wish we would get this nailed down. Because for somebody to own a dispensary, for one of their members to do the illegal redistribution, that member should be prosecuted. If it came to the attention of the dispensary and they continued to serve that person, they should be prosecuted. But for it just to result would then result in their losing their permit. Do you see the conundrum here a little bit, Mr. Wiley?
Mr. House, where are you?
Okay, I was referring first of all to page 9. E2. And then we had, let me just see here, we had 16. Other language that seemed to address it on page 16. And there's a couple of different places in there. So anyway, I just draw that to your attention. We want to find consistent
it's sort of
language.
Repeated, but I'm not seeing.
Well, the issue is if somebody does something illegal with something I legally sell, okay, so I sell something and they go out and do something illegal with it, they should be prosecuted. If I continue to serve them and they continue to do something, and I know about it and I do it, then somebody should go after me. But if it's just a passive thing that shall not result in, that language is so soft.
I see the concern. The language is just too unclear. It's too passive.
I think you can do a tighter version of that, and we'll be.
The later version's probably clearer.
Yes, sir.
Yeah.
That was the idea. Okay, we're getting down to it here. Just about done. You would not believe how many okays I have in this. It's just amazing with just okay checklist. A question on page 14. Number 2 at the top. Last sentence. Talks about all such cash and in-kind amounts. Maybe this is not necessary to say this, but what if they paid with a check or credit card or something? When you use the word cash, Mr. Wiley, are you talking about that kind of, you don't mean just cash only, right? You mean payments or something, monies or?
That's a good question. I think it could be clearer that the intent here is you document cash transaction, because otherwise you don't have any documentation of cash transactions.
And I don't dispute the intent. I'm just looking for language.
We could clarify that all transactions, all exchanges should be documented in some way.
Okay, going to number 3, the next one. This is the one that was kind of a biggie, and we were talking about it last time about the cultivation and the area. One basic principle I might suggest, if we really mean it, that those who are cultivating and those who are members of the cooperative, that they are members of the cooperative, so it's a closed circle, right? Then the geographic areas need to be the same. And the geographic areas, if you look at the state, they have ID cards for the entire state. And I know that we got a letter from one of our supervisors that had a concern about us identifying a specific county, in this case Santa Barbara County, and how they might be enforcing it. I think probably not unexpected for me, but I don't know that we need to put a geographic definition here, and that begs a lot of questions, I know. But the key there is that members of the collective, there'd be a closed loop, that members and managing members and the patients, caregivers, all of them whatever we identify, it needs to be the same geographic region, because otherwise it doesn't make sense. You would not have a member that was cultivating that was outside of the geographic region that members could be in. And then secondly, I think we run into a problem when we identify specific counties or specific areas. Like, for instance, we have the Tri-County area right here identified. State law doesn't do that. State law talks about the card holders, and they offer this as a statewide phenomenon. You don't have to have a card. And I don't think it serves us to identify a specific geographic region smaller. And it goes to the big question, Mr. Wiley. I didn't see anything in the state law that talks about local. I know you've been holding on to that pretty hard, and I don't see how the word local, I don't see where it's defined, where it's even used in any of the state law at all, or even in the guidelines that we got from the Attorney General. So maybe you just take a minute with us and talk about local.
Well, Councilmember House, as you mentioned, I think, right, your first remark was the cross-reference, the state statute, I don't have it handy, that the SB 420 statute that expressly says that cities can do ordinances consistent with SB 420 and the Compassionate Use Act. So clearly the state anticipated local ordinances. Well, you know, and each ordinance, each city is going to have its own local requirements. It gets back to what is our concern? What is our local concern? And again, it's a storefront concern. It's preventing crime, preventing nuisance impacts, if you will. And when you think in those terms, then so can you, for example, say that the marijuana has to be cultivated in your county? Why would you, as a city, want to say that? And I think there is a connection. There is a possible rational connection that could be explained. We're trying to keep this by saying that the marijuana, for example, would come from your own county. We're trying to avoid transactions that deal with possibly people who cultivate this professionally and for a profit. That we're trying to make sure we're dealing with a collective of local individuals. Now that maybe begs the question, well, could we say that it has to be cultivated within the city of Santa Barbara? But my concern there, my reaction there is that possibly goes beyond your concern a bit too much, and it would be possibly burdensome on the state law to say that it had to be cultivated within the city, and it doesn't possibly really forward very much your concept of you're trying to deal with local collectives. In other words, I'm not saying it very well, but it seems to me it would be legitimate to say only within Santa Barbara County, because that'll get us to collectives that aren't dealing interstate, maybe with Northern California. And those are not the kind of collectives that are going to be fully complying with the SB 420 statutes. That's just, you know, a rationale, and that's why I think it would be, if the council wanted to say that the marijuana had to be cultivated within Santa Barbara County or within the Tri-County, I think that would be defensible. On the other hand, I'm not so sure it would be defensible to say the cultivation has to occur within the city of Santa Barbara, particularly with our county where we don't have even agricultural zoning in the city of Santa Barbara. So.
Okay, that's helpful. I guess basic principles, just to get back to them, and then it would be actually in a practical matter. We have heard testimony from one organization that's been here for the past 10 years, operating successfully, quiet, under the radar, doing what I think that we've wanted to see based on state SB 420. One of their main members of their organization is in LA, and they only distribute directly to them. They're part of a closed loop. So I worry about that, and I do think that whatever we do come up with, we need to make sure that it's the same for members and members, of course, who are cultivating. That's part of the system. So I'll put that out there for us to maybe chew on when we get there. Almost done. Then a couple more things. Then, and on page, let's get this here. Oh, almost all this is just fine. On page 22, there's on page 22B1, and this goes to something that's been around in Santa Barbara for a while, but I just want to request a reconsideration of this. This is where the dispensaries that are what we call legal nonconforming, and we've given them a limited amount of time to comply or go out of business. One of the rules was that they had stayed in existence continually, and that if they had shut down for any particular reason for 30 days or more, that they would be out of the legal nonconforming category. I know of one situation where they were certainly very quiet for 30 days or a little more because of the DEA's attempts to close down all dispensaries. And yet, by all intents and purposes, they've continued on for continuously through that period, but just very quietly. So my question is, why 30 days here? It says the operation of the dispensary or collective dispensary is not discontinued for a period of time in excess of 30 consecutive days. Why not 60? Why not 90? I mean, the main point being, have they been in operation as in my instance that I'm suggesting, as a good neighbor and has been a very responsible partner in crafting these ordinances? In fact, the 30-day has become a death sentence almost. And I don't see why we need to use the number 30 days. And Mr. Wiley may want to chime in on this. I know you've been putting your hat on that one too, because you've been going after that one dispensary in particular based on this. And anyway, I just would ask us to reconsider that, maybe a longer period of time, if it wouldn't be, if there weren't any other important justification for having the short 30-day number. I think that covers it. The big issues are all out there. Oh, the edible business, and that has come up today. One of the things I understand about this edible thing, and I understand the concerns about the children getting lollipop kind of things. I definitely can see that issue. Edibles, however, the things you might put under your tongue, sublingual kind of administration of medicine, can be the most effective and appropriate way for somebody to take this as a medicine. It has a lot of very technical reasons why that would be better than smoking or inhaling from a vaporizer or some other other way. So I'm not against there being, I didn't see on this one page 16 in number 2880090 that you mentioned edible marijuana, but it wasn't mentioned in the context of it being, well, let's just read it. A collective dispensary management member or member shall not cause or permit the sale, distribution, or exchange of medical marijuana or of any edible medical marijuana product to any non-collective management member or member. To me, that was that clear language we were looking for. Now, that's right. We want to keep that tight within this very closed circle of members. Now, that language I can support. But if we were to go on further and somehow try to cut edibles out of the mix, I don't think that from a medical perspective that would be helpful to some of the patients who have a legitimate need. Those are my remarks. Thank you very much.
Thank you, Mr. House. Mr. Hotchkiss?
I think Mr. House makes some good points. I would agree with the edible thing also, because if somebody has a lung problem, lung cancer, they're going to need to take marijuana medically in a way other than smoking it. So I wonder if we really can get into just compensation, how we do that. That's sort of a sticky subject. Mr. Wiley, how would we do? I mean, what's just compensation?
Councilmember Hotchkiss, I think the federal government's been dealing with what's just compensation for CEOs
right.
of Fortune 500.
Right.
And, my view is it's clearly a subjective thing that is not amenable to black and white rules so that you can, say this is and it isn't and it's all in writing. That the only way you could do this is retrospectively with a judgment call. That you have a standard like the City of Long Beach and their ordinance says you can compensate collective members for their time so long as that compensation is typical of what a nonprofit employee might make. And that's for that same position. And then if maybe you've got probable cause, you've got evidence to believe that someone is violating the ordinance or violating state law, and an investigation occurs, and you see someone making, a six-figure salary for being a receptionist. You think, I think they're violating. They're really operating this for a for-profit basis. This ordinance really, other than stating the principle that it's supposed to be not-for-profit and just reimbursement, doesn't get into that.
And
I just wouldn't want people, if they're running a approved collective, to be worried that they're going to get jumped on for what you and I might deem as unjust compensation, and they think is just. So I don't know, maybe a little guidance there, one or the other. All right. I would take up Mr. House's point about local collectives and local groups, and therefore would reduce the area of growth to Santa Barbara County and make the area of subscribers, whatever we're going to call these folks, also in Santa Barbara County. And I'm wondering if at this point, because basically I think we're in agreement on other things, if it would be appropriate for me to throw out make a motion and see how the rest of the committee views it, and if you like it, we vote for it. If we don't, we don't.
Well, at this point, so you've completed your comments on...
Yeah, pretty much. I think so. I mean, I think most of what the staff has proposed is good. I would note that in case the public has seen that the staff crossed out the limit of within 500 feet of a school, the reason they did that was because effectively all the other rules in there accomplished the same thing. So it wasn't in disinterest to protect young people that was put in there. So anyway, yeah, I'm ready to make a motion.
Okay, well, okay, and I'd like to participate a little bit here, and then...
Oh, my gosh.
And then I'll be looking for motions, and we're even in a pretty good time here. First of all, I want to note that Supervisor Wolf did send an email expressing concern about the growing of marijuana in Santa Barbara County, and I believe Mr. Wiley did receive that email as well. Could you comment to it and perhaps précis quickly the message and then our response to that, or your response to that, should I say?
Chair White, as I understood it, the concern was that in saying that a collective dispensary permitted by Santa Barbara would have to cultivate its marijuana within the tri-counties, including Santa Barbara County, that somehow we implied that it was therefore legal to cultivate marijuana within Santa Barbara County. And I just think that that implication is mistaken, and the reason is because this is all regulated by state law. And state law does clearly allow individuals, for example, if they're a qualified patient, to cultivate medical marijuana for themselves. And if they live in Santa Barbara County, they can do that. And it allows primary caregivers to cultivate medical marijuana and provide it to a qualified patient. And if they live in Santa Barbara County, they can already do that. And we're not going to change that, and we are not changing that. And as the Attorney General guidelines points out, you can do this collectively. You can get together as a group and do it collectively and provide. So again, and that can occur in Santa Barbara County. And I know that the county, I believe the county has an ordinance that imposed a moratorium on dispensaries, but that's the storefront aspect that we're not really talking about here. So I did discuss this with someone from the county counsel's office. I suggested we could repeat again that nothing in this ordinance authorizes anyone to do anything contrary to state law. We say it several times in here, but we can say it again more specifically with respect to this point about cultivation and where the cultivation can occur, if that reassures the situation or clarifies it maybe. But it would really only be just a clarification at best.
Okay, thank you. Back to a couple of points that Mr. Weston made. Number one was the change of location and a concern that that would eliminate an entitlement. Is that am I clear, Mr. Weston, with what the concern is? Could you speak to that, Mr. Wiley?
Mr. Chair, that's pretty complex, but you know we might want to go over this because now that we're talking about maybe less than 7 or 8 locations or permits, it can become critical, and it has to do with the last page of this ordinance. None of that's new. That's been around for several months now, and Mr. Cotto is going to have to help me go through this. I'm not sure, I can't recall if the committee actually went over this, but as I say, it becomes more critical if, for example, there's only going to be 5 permits. Section 2A, dispensaries permitted under the March 2008. Well, let's start at the beginning. The 5, at top of page 7, subparagraph E. Notwithstanding the above, the city may not issue a total of more than 5. And it was our understanding there was a consensus reached on that last week, but
it's a specific number, a very small specific number. Let's just say that at this point.
The city may not issue a total of more than 5 collective dispensary permits at any one time, and no more than 5 permitted collective dispensaries may legally operate within the city, including those dispensaries which are open and operating in a legal, non-conforming manner at the time of the adoption of the ordinance amending this chapter. If I understand correctly, getting back to this last page, number 2, we've got 3 legal operating dispensaries under the March 2008 ordinance, and that's what this A is referring to. There's 2 on Milpas, 1 on Garden. Is it Garden? No, Olive, yeah. That were permitted under the March 2008 ordinance and opened. So already out the door, 3 out of the 5 were taken. Then B says those dispensaries which opened and operated in a legal manner prior to the effective date of the March 2008 ordinance and which have remained in a legal non-conforming manner of operation since the time they opened. And if you recall, we're referring here to those dispensaries that opened prior to March 2008, sort of when this all started happening, and there was no regulations. We'll get to that. So those which opened prior to the original city ordinance and remained as a legal non-conforming use for a period of 180 days, and have remained in a legal non-conforming manner of operation since that time, may, despite its non-conforming location, which I believe may be Mr. Weston's client, remain as a legal non-conforming use for a period of 180 days from the effective date of this ordinance, provided that they implement and observe the following operational conditions. They operate in the operation has not been discontinued for a period in excess of 30 days, and I understood that Councilmember House was suggesting that be changed. Right. That the operation of the dispensary complies with all portions of Chapter 2880 as revised. That's the operational, that they operate. And that they be subject to the city's general non-conforming use ordinance, which provides for ways that if they discontinue their operation, they then cease to be legal, and also, I believe, imposes requirements that they not expand and that sort of thing. I'm not sure, so number one, this sets up this 180-day period, and maybe Mr. Cotto knows, I believe only the one dispensary on State Street operated by Ms. Poet remains legal non-conforming and has remained legal non-conforming since prior to the March 2008 ordinance. It's my understanding from the attorney in our office that handles the code enforcement that there may be one other dispensary where they provided us with evidence that despite initial evidence from the DEA that they had discontinued, that they provided us with some fairly convincing evidence that they did not discontinue, and I believe that's located on De La Vina. So right there, if I'm correct, that's 5 out of 5 that are already taken. And of course, they can, that's for 180 days. And that would, unless I'm misunderstanding this, would maybe, assuming the 3 that were permitted under the March 2008 ordinance continue, that would maybe open up 2 possible new locations in 6 months' time, where someone who didn't conform, their location didn't conform, could possibly move to a location that did conform. Did I get that right, Danny?
Yes, and if I could add, maybe from a processing standpoint, what this poet does have an application in, and they're one of the first in line, depending on how this all works out, to be processed. And I'm not sure that it would be out of line to say that they could move forward and get an approval, and then they wouldn't actually be able to occupy and open until the old one closed. We might be able to do something like that within the language of the ordinance that's here.
Well, that reminds me, the last section here suspends our suspension ordinance, where that ordinance said you could apply and you could get your application deemed complete, but at that point it just was on hold. We can do anything we want because they're all our ordinances. So if we wanted to, as part of this ordinance, alter that suspension ordinance and say, create this process where within the next 180 days, if there was an open location, someone could apply for it and go to the point of even getting fully processed and then not opening until the 180-day period passed. Or if they wanted to, I suppose they could just move to the new location if it was one of the existing ones.
Right. So then back to the 3700 block dispensary collective. That is now on our list, however, of allowable locations. Is that not right? No. Okay. It's still within 500 feet of the park, and so and your concern is to lose an entitlement, although you have applied for another entitlement elsewhere. Is that? And may I'd ask Mr. Weston that if I may. Yeah. Well, yeah. I'll do it.
I've only had a few minutes to look at the ordinance, and I'm just trying to raise a technical question that I was afraid that a new permit couldn't be issued replacing the old one because the numbers wouldn't count correctly. All we want to be able to do is if we get a permit for a different location, we want to close the old one and open a new one and don't want to be foreclosed unintentionally by any language in the ordinance.
And that's exactly what I'm trying to get at, and that's where this ordinance is headed at this point, gentlemen. Okay.
You can certainly do that.
Okay. Good. Well, that works for me. Let's see. On the edibles, I agree with my colleagues that there clearly is a need for edibles. I appreciate that there's a risk of it broadens the market, as it were, for the risk. But I also do believe that it's a critical piece of the therapeutic element. Mr. Wiley, the whole point of people gaining access to the facilities for purposes other than participating in the medicinal process of repairs and services and so forth, that makes sense, I'm sure, and that point you've noted. I think we've. Then I guess the other one that is up for grabs is the what's local. Is it county? Is it city? Is it tri-county? Is it the state? And my gut feeling is one of enclosing the circle in that Los Angeles doesn't feel local to me. I feel like that opens the system up somehow to a country. It's no longer a community, but it's to a country. So that's of concern to me. Tri-counties, I feel like we are siblings in many ways. The Ventura is a more populous county, but nonetheless, there's the elements of similarity there that work for me. But so I'm hearing we have a really broad range of view on that issue at this point. It isn't a deal killer for me, but it's one that I at least want to put out there for my. A lot of this is uncomfortable. The whole process is uncomfortable. And I think we hear it in the testimony, in the eloquent testimony today about the concern for people at risk and for our children and for people who really need this for medicinal purposes. Where I end my comments. So, for me, finally, on the question of number, I feel like we have too many dispensaries on the east side in general. And we don't have enough, and I think we have probably the right number, i.e. 2 more in the rest of the city at this point. I feel like using the term cottage hospital, whatever we want to call it, the medical professional medical neighborhood, something to that effect, may work, and I guess what we'd be seeing is we want to have one dispensary, and I'm not recalling if the ordinance deals with this. We want to have one dispensary in each neighborhood. Is that right, Mr. Cato?
Maximum.
Maximum, yeah, maximum of one. So then we end up with a nonconformity in the east side area there, in the Milpas in particular. I don't know whether Olive and East are the same neighborhood. No, they're separate.
Yeah, the Olive Street dispensary would be in the downtown east, where the 2 on Milpas would be in Milpas.
But so the downtown east, if it becomes, in the ordinance does say, at least we've had a discussion that said downtown is out, right? At least 2 of us just said that last time. So that would make the Olive Street one a nonconformity at that point. The 2 on Milpas that are there would be a nonconformity with the 2 on Milpas, but they wouldn't be subject to the 180 days nonconformity. They would be. I mean, you're not going to. Okay, they both close in 180 days. No, I mean, is that where it would go, or?
Chair White, that's correct. Actually, all 3 of them, as is currently written, the Olive Street one and the 2 on Milpas, would not be subject to the 180 days. They would just be allowed to continue, and they would be eliminated by attrition.
Okay. So then we'd end up with 2. That's the only way that I get to a number larger than 3, because I see that I'm obviously making a real accommodation, or I'm supportive of the 3700 block facility. It has felt right to me all the way along. So I'm looking to accommodate that, and then I'm looking for one in the professional medical community. That's kind of my. And if I could do anything, it would be to say there's too many in Milpas, and we ought to have. Although I don't have any criticism of either one, I just feel like there's an oversupply there, and I wish the neighborhood concentration had been policy had been in place sooner, because these just happened. This all happened very recently. So I beg your pardon for taking this kind of time, but I'm thinking out loud and trying to get this as right as it can be for me. So I can go along with the 5, but with this notion of, I'm hearing that we have the language that will allow the 3,700 facility to move, and I'm seeing a cringe. And that the Delavina one, then, does that go on the 180-day, or is that long-term? That goes on the 180-day nonconformity? Okay. And that the medical professional neighborhood would be another possible location for one in the future. And with 5, we would then have one, with the Delavina one closing in 180 days, there would be a possible opening for one at some other place?
Mr. Chair, there is the possibility that the Delavina dispensary could be approved, legalized in place. So that's
understood. And that's actually, it's not that far from the medical professional community, is it? I mean, it's kind of, I don't think it would be too much gerrymandering to make that. I know we've talked about the Mission Street, Pueblo Street area as being either 2 areas, or it could be just considered to be one larger one, and that's not that far away. Again, bear with my ponderous process here, but edibles, the locations, the nonconformity is a big issue for me. I feel like we've worked hard on the issue of closing the circle of recreational, of providing the tools to get away from this being a recreational model. And I have faith in our enforcement system to be able to optimize that. And so I'm comfortable moving forward with those pieces. And so with those comments, I'm looking for a motion. Mr. House, you have other comments?
Prior to a motion, I know that Mr. Hotchkiss is ready to do that. I just wanted to ask Mr. Wiley a question about the 3700 block of State Street location situation. Right now, legal nonconforming, and of all of those, it's been understood that they've complied with everything, and they will have 180 days, or if we go by the language that we have here, to comply, meaning that they would have to move. And in almost the same spirit as I'm hearing from Mr. White, is there? I mean, given you don't want to do more harm. Number one, as a basic principle. In this case, this is an organization that's been there for many years and has pretty unblemished record. I mean, there's probably been one issue that wasn't their fault years ago. It was, I think, a burglary or something, but that was it. I mean, is there a way for us to declare, if you will, a legal nonconformity, and that if ever they were to go out of business, that'd be the end of it in that location because of its proximity to that end of that park? Or I mean, is it impossible to get there from here? Because right now they're having to do quite a bit to find another location and go through that whole vetting process, when right now they have a willing landlord. The adjacent neighbors have been supportive, and they've been really innocuous in that neighborhood. Is there a way to get there from here on that? Or is it just off the table?
Councilmember House, yeah, there probably is. The drafting escapes me a bit right now. Number one, let's make sure we're clear. I think we're talking about 3,100.
I'm sorry, I used the word. My apologies. 3,100, 3,120 something.
Actually,
my mistake.
The allowable locations has the 3,400 through the 3,900
yes,
block.
Sir. So thank you for clarifying.
And I believe that's too close to McKenzie Park.
Right. That's the issue.
So.
But they've been there for many years. It hasn't been a hub of bad activity. In fact, the biggest issues in the neighborhood have to do with another organization that's down the way. It has nothing to do with medical marijuana. So
Yeah, and I think the concept here would be to grandfather in some way, on a long-term basis, an existing legal non-conforming one. But the dilemma is, it's hard to start drafting these one.
I understand.
Instance, and not then have to explain, well, why didn't someone else?
Exactly.
Why did they have to comply? And the answer can't be, well, you're close to a park. Well, they were close to a park too. But I think we could get there. We can draft something and maybe bring it back. I'd be inclined actually to work with the exhibit where dispensaries are permitted, and at least that gets to the point. Say they're permitted in the 3100 block so long as they're legal at the time of the adoption of the ordinance.
There you go. And now that wouldn't transfer. You could. Right. The idea is it doesn't get to transfer ownership. I mean, all those other things, so that we're not, encouraging that forever. Just like we're hoping by attrition in the Milpas area to recover just one, not have this over concentration. So I'm just opening that up, and if we could get there, that might be helpful. And I don't think it's a necessity. I think it would just be towards peace in the land to some degree.
Okay. Thank you, Mr. House. And I think it was a good conversation. Thank you. Mr. Hotchkiss.
I've been taking this from a little bit different viewpoint, which is not so much the businessman's viewpoint, but the community is what I've been trying to think of. And so rather than say, will this stay in business or that, I haven't addressed that at all. So I'm going to propose, if I may make a motion, that we adopt the following: that medical marijuana should only be made available. I'll give you this is written down, Danny, so you don't have to write like crazy. May only be made available to qualified patients at any location if such a location is operated as a collective in the manner required by SB 420. That's already in what you've written. Number 2, cultivation by a collective must be documented as local, i.e. In the county of Santa Barbara, which, Grant, I know you may object to, but I want to try that. That number 3, records of collective membership must be confidentially available to designated city staff, and on-site inspections by specified city staff may be made without prior notice due to possible infractions. So that gets around the warrant problem a little bit. Number 4, qualified patients of any collective must be Santa Barbara County residents with some official identifiable documentation such as a driver's license or other proof of ID. Or residents, sorry. Number 5, no collective shall be within 500 feet of the 17 major recovery centers that we addressed before. Number 6, no collective shall be located within a residential zone of the city, which we've already got and I think all approved of. Number 7, no collective shall be within a mixed-use complex, which you've already got. Number 8, no collective shall be located within 1,000 feet of another collective, which would take care of the Milpas problem. Number 9, no collective shall be located on a parcel on State Street between Cabrillo and Arriaga Streets. And let me explain that a little bit because we had the downtown question. And downtown is much bigger than that. I'm just talking about the immediate commercial zone, so I'm limiting it to that. We said that edibles are okay, that's fine. I personally wanted to have restricted hours of operation and deference to the schools, but I'll compromise on that of necessity if we can move some of these other things forward, because now I'm going to ask you gentlemen to make a compromise also. In deference to Mr. Howes, there shall be no downtown blanket restriction, as you requested. And in deference to Mr. White, I think the number of dispensaries should be reduced to 4, if that's possible. So that's my motion. I'll look forward to a second or not, as you gentlemen feel appropriate. Thank you.
Thank you, Mr. Hotchkiss. If I may look at there. Thank you. There was. I think that first of all, the records collection portion. I mean, I think we should get our council. Does council have a copy of this?
No.
Okay. That might be useful in any. But I was concerned that might not be. It's hard to take this and template it over the draft ordinance, and I don't know about the locational aspects of things, whether that's different than what we have now, and maybe as or is that just a repeat of?
That is a repeat of everything that's already in the ordinance. As
Okay.
far as 500 feet from the recovery centers, not in residential zones, not in mixed use, 1,000 feet from each other.
Okay, if it's the same, I'll believe you if it's the same.
Mr. Chair?
Yeah.
On that point, can we just go over what Mr. Hoskins said on State Street? Was it, I missed it.
It was on State Street between Cabrillo and Arriaga.
No storefront on State Street. Okay.
Right.
It wasn't a location. All right.
Right.
So that's already in there. Yeah.
That's in the ordinance.
Right. Okay. And down to 4. We're talking about this nonconformity exercise. Well, first of all, then, and how do you feel about the points that you're making there? You're supportive of this?
Yeah, I just wanted to highlight the things, because there's a lot of language here that Grant pointed out, so I wanted to try to simplify and highlight what I think are the key points that we could turn back to the council.
Okay, and then also, but you're also supportive of there's lots of language in here.
Yes.
And you're thinking we're heading in the right direction on
Right,
that.
and I, like Grant, have okay and check marks after all the other stuff.
Okay, good.
Mr. Chair.
Mr. House.
So, the things that we had discussed in my soliloquy, you're going along with that. I think we still have some language to work. The big issue about planning commission, that whole approach, that's something we're going to take up after this. And one of the big issues that still is remaining in your list is the Santa Barbara County, which I really can't support that. I think that's too narrowly defined. We are a community of the tri-counties, and that, to me, really does hang together. Our literally the workers who come to town, and this is that. So I could support tri-counties. Santa Barbara County alone, I could not. So I just put that out there.
Would you support tri-counties for cultivation, but not for participation?
Well, I don't see. That was the issue I raised earlier, because you have to be a member the cultivators have to be members of the cooperative to keep the closed circle, and that's why I'm going there. And then, so that would be one I'd have a difficulty with your motion, but I could support it if it changed to tri-counties. And then this issue of 4 versus 5, I think we really hit the magic number with 5. If you listen to the way Mr. White was just talking about it and our staff, you actually begin to have, it's a smaller number than I felt originally, and I still think more would be appropriate, but 5 actually makes sense. And you can see how, geographically, that wouldn't mean every one of the locations was occupied, if you will, but you would have, by attrition, you'd begin to have a more equal distribution throughout the community. And they would be legitimate operators that are, right now at least, they're known quantities, which I think is helpful to the conversation. So if you had the number 5 and you have tri-counties, the only issue I see yet, I tried to keep notes here, was the issue Mr. White had brought up about the confidentiality of some of the records. I understand Mr. Martell's concern. I do, because first of all, the inspections and the need to be able to respond to a complaint. How do we get the balance right with patient-doctor confidentiality? That is my biggest concern with regards to access there. And if our attorney could help us get that tightened down to protect and preserve that confidentiality, I could support that. The rest of it was stuff that's already in here. So you support my suggestions and additionally the ones that I've just checked off, and could you change it to tri-counties and 5, and we might have a winner.
Could I ask Mr. White to weigh in?
Tri-counties and 5 works for me. I feel like, again, we've got too many in the east side, the Olive Milpas area, and we would be starving the other side of town by going with 4.
All right, well, let's change the motion then, since you both think that, up to tri-counties and the number 5. I think the 1,000 foot between collectives may resolve your Milpas problem, but I'm not sure.
Well, it's long-term non-conforming, however. And so at attrition, it wouldn't be like 180 days. It would be when and if one or another goes out of business. That's the only thing that's going to stop that from occurring.
That's been all along. We knew that was going to happen because it's an area. There's only going to be one in each area.
All right, fine.
I need to ask Mr. Wiley a question regarding this. Do we have a limitation that no one under 18 can go into a dispensary? I didn't see that in there, but I think it's important.
You know,
I think we have it in there.
Mr. House, believe we should have somewhere in the original ordinance.
Okay, I want to just be
Yes.
sure that stays in there. That's critically
It
important.
may be qualified unless they're accompanied by their parent. Or maybe I've been reading too many of these ordinances lately.
Okay, if it's in there, I'm good with it.
Okay. All right, so we have a motion, and do we have a second?
I second that.
There's a motion and a second for a recommendation to council for a medical marijuana ordinance as discussed and supported today. All those in favor say aye.
Aye.
Aye. Opposed?
Mr.
Okay.
Chair,
Mr. Wiley?
I wonder if we shouldn't come back with a new draft of the ordinance to the ordinance committee or not.
I think that's a good idea.
Okay.
I think if we have the time to do it, let's do that.
Yeah, I'm good with that, too.
I think we can do this in 2 weeks. I know Danny and I talked, I'm going to be out the 22nd and the 23rd, but if we work on it, the agenda should be finalized by then.
All right.
And what I would suggest, it's getting a little too confusing, it seems to me, to keep showing all these different changes. I'd suggest at this point for the committee and for the rest of us, a clean copy that just has the ordinance that we understand there to be a consensus on.
Okay.
When we go to the full council, we'll then show changes from the existing code. But I think it would be easier to follow if we just looked at it, reviewed it all as a new ordinance, and maybe at that point we can talk about whether there's still a role for the planning commission and the planning staff.
I think that would be a
Thank
good
you.
time
That's
for us to discuss
a
that.
good other issue that we need to discuss. Thank you, Mr. Wiley. All right, so then we'll be back in 2 weeks for further discussion. Mr. Cato?
Chair White, I just want to say that when we were at council last on the 23rd, they did direct us to come back within 60 days, and so we just won't make that. Maybe you could make that announcement when you report out from this committee.
That we will be a little later than 60 days?
Yes.
Okay. How much later?
Probably two to three weeks.
Okay, thank you.